Welcome back to The Explainer. Today, we're diving straight into a phenomenal piece of jurisprudence, GR No. 269921, Spouses Agullo v. Lia Victa Espinosa. It's a completely fascinating case that untangles a procedural knot that stumped even the lower courts, and it gives us the perfect opportunity to really master the distinctions between possessory actions. So let's get started. Here is our roadmap for this case digest. First, the facts of the dispute. Second, the procedural history below. Third, classifying the action. Fourth, the one-year rule clarified. Fifth, the Supreme Court verdict. And finally, our key legal takeaways. This acts as our structured outline to solve the legal puzzle ahead. Section 1. Facts of the dispute. Okay, let's dive into this basic property encroachment that started it all. Every great legal battle usually starts with a simple disagreement over a piece of earth, right? Well, this timeline begins when respondent Lia Victa Espinosa purchases a parcel of land. Being a diligent owner, she has it surveyed. But, the survey reveals a problem. The petitioners, spouses Agullo, were actually encroaching on a portion of her new property. Espinosa makes a demand for them to vacate, but the spouses Agullo flat out refuse to leave. So what does Espinosa do? She heads to the regional trial court and files a complaint for recovery of possession, praying that the spouses Agullo be ordered to vacate the premises and pay damages. Sounds simple enough, doesn't it? Section 2, procedural history below, because what should have been a standard case quickly morphed into a chaotic, procedural ping-pong match between the lower courts. Just look at this stark contrast between the lower courts. The RTC, without even issuing summons to the defendants, threw the case out immediately. The judge summarily dismissed it as premature, reasoning that this was actually a case for forcible entry, and therefore, Espinosa had to wait until a full year had passed from discovering the dispossession to file for recovery. Espinosa filed a motion for reconsideration, it got denied, so she elevated it to the Court of Appeals via certiorari, and the CA, they completely flipped the script. They set aside the dismissal but ruled that the complaint was actually an Accion Reivindicatoria, an action to recover ownership because she sought possession as an element of her ownership. Literally, two courts, two completely different classifications. Now, putting on our civil procedure hats for a second, let's look at the RTC's first massive blunder. The RTC dismissed the case motu proprio, meaning on its own, before even issuing summons. But under Rule 9, Section 1 of the Rules of Court, there are literally only 4 specific instances where a judge can dismiss a claim motu proprio. Those are lack of jurisdiction over the subject matter, litis pendium, res judicata, and prescription. Do you see prematurity anywhere on that list? No way. That procedural misstep alone meant the RTC was absolutely in the wrong. Section 3. Classifying the action. Now we arrive at the climax of our analysis, where the Supreme Court has to step in and correctly classify what kind of complaint Espinosa actually filed. Now, what's really interesting about this slide is how the Supreme Court used the precedent in Makodi v. Samoy to prove the CA was completely off base. In Makodi, the plaintiff filed a complaint captioned Accion Reivindicatoria, but only actually prayed for the surrender of physical possession and damages. There was zero prayer for the recovery of ownership. The court in Makodi ruled it was just an Accion Publiciana. Looking at Espinosa's complaint side by side, it is the exact same scenario. She just asked the court to order the Agullos to vacate and pay damages. She didn't seek recovery of ownership or annulment of title anywhere in her complaint. And as we all know, jurisdiction is determined strictly by the allegations in the complaint. Think of this as your ultimate flashcard for the bar exams. Let's break down these 3 distinct possessory actions. Accion Interdictal under Rule 70 is for physical, de facto possession, filed within 1 year. Accion Reivindicatoria is for recovering actual ownership. And sitting right in the middle is Accion Publiciana, a plenary action to recover the better right of possession, or possession de jure, independently of title. Because Espinosa wasn't asking to be declared the owner, but rather asking to recover her right of possession against encroachers based on her existing title, her case is squarely, undoubtedly, an Accion Publiciana. Section 4, the one-year rule clarified. But wait, even with the correct classification, the spouses Agullo argued the case was filed too early, which brings us to a massive doctrinal clarification by the Supreme Court. The spouses Agullo basically said, sure, maybe it's an Accion Publiciana, but you have to wait a full year of dispossession before filing it. Since Espinosa filed earlier, they claimed it was premature. Well, the Supreme Court flat out said that's inaccurate. Drawing from the landmark case of Heirs of Lim, the court clarified this absolutely crucial nuance. You do not always have to wait a year to file an Accion Publiciana. If the deprivation of possession was not achieved through fists, meaning force, intimidation, threat, strategy, or stealth, the classic Rule 70 elements, then you don't have to wait. For non-Rule 70 dispossession, you can file your Accion Publiciana immediately, even if it's been exactly 1 year or less. The spouses Agullo tried to cite an older case, Martinez, to support that rigid 1-year waiting period. But the Supreme Court took this opportunity to explicitly correct a misquote from that older ruling. Let me read this to you directly from the court. Clearly, what the court meant to say was that while possession can no longer be wrested via a summary action for ejection when dispossession has lasted for more than a year, the dispossessed party may still file a complaint for Accion Publiciana or Reivindicatoria. Hence, the phrase can be filed instead of shall be filed. To say that an owner has just sit around and wait for a full year to pass before seeking recovery of their property in a non-Rule 70 situation, that is just absurd and defies all logic. Section 5. The Supreme Court Verdict. Let's look at the final resolution of this procedural thriller. We've debunked the RTC's procedural errors, we've corrected the CA's classification, and we've smashed that 1-year myth. So ultimately, the Supreme Court ruled to deny the Agullo's petition. They affirmed the Court of Appeals' decision to reinstate the case, but they did so with a vital modification regarding the classification. The complaint is officially an Accion Publiciana, and because the assessed value of the property was 68,060 pesos, it falls under the RTC's jurisdiction. So it was correctly filed before the RTC all along. The trial court is now finally directed to decide the case on the merits. Section 6. Key legal takeaways. And this brilliantly illustrates exactly why we study these cases so closely. So let's distill the ultimate lessons from this explainer for your practice. These are the foundational takeaways every law student and practitioner must commit to memory regarding property recovery. Number 1, jurisdiction is determined by the 4 corners of the complaint's allegations, not what you argue later in a motion. Number 2, a claim of title in the answer doesn't magically convert an Accion Publiciana into an Accion Reivindicatoria. The court can just resolve the ownership issue provisionally to settle possession. And number 3, our golden rule for today, Accion Publiciana does not rigidly require a 1-year waiting period for non-Rule 70 cases. So let's test your understanding with a final provocative hypothetical. If a neighbor accidentally builds a fence encroaching on your land, meaning no force, no stealth, just a mistake, do you have to wait 366 days to file an Accion Publiciana? Based on our deep dive into the Agullo ruling today, the definitive answer is absolutely not. You can file it right away. I hope this structured breakdown gives you total clarity on untangling possessory actions. If you found this explainer valuable, please make sure to comment, like, and subscribe to join our community of shark legal minds. I'll see you in the next explainer.